Wow, I remember in 1994 and 95 when Anna and Andrew and I were presenting for EOB and LegCo, we used to get the most amazing comments on LegCo. I remember one legislator when we were taking him through the employment discrimination provisions and the genuine occupational qualification requirement exemption, and he said, does this mean that people can say I don't want to hire a woman security guard? And we said, no, that's not what that exemption is for. He said, you mean women can be security guards after this bill is passed? And I said, yes. And I still remember what he said. He said, I find that mind-boggling. And he was he was actually one of the more supportive members. And then there was another member of LegCo, I'm not naming these guys, but who asked, as he read through the bill, he said, will I still be able to ask young solicitors when they apply for a job if they're on birth control? We said, no. Are you doing that now? But these comments, the point is, I'm sure a lot of people are still thinking this, but the point is, in 1995, they would say it openly in Bills Committee meetings, and they did not feel embarrassed to say these things. So we have come a long way. In 1996, the EOC just started to open its doors, but it hadn't done the investigation of the SSPA system yet. So most of us did not even know that boys were having their points bumped up by the government in the secondary school allocation system. The crimes ordinance still did not prohibit rape within marriage at that time. Judges were still giving that horrible corroboration warning in rape trials. So think about where we've come 20 years later, right? We have many important cases that have been decided by the courts enforcing the SDO. We've had cases in pregnancy discrimination, unequal ages of retirement, the Cathay Pacific case. We have, of course, had the SSPA judicial review. So this is huge. And the case on the SSPA was important not only because it told the government you have to stop raising the points of boys, but also because the judge in that case said that the CEDAW treaty should be looked to for guidance in interpreting the sex discrimination ordinance. That's a very important precedent, one that a lot of countries still do not have. We've also got rid of the cautionary rule, corroboration rule in rape trials. We now do have a law that prohibits marital rape, and the domestic violence ordinance has been expanded. Okay, I've got 2 minutes. I was asked to do 3 goals. I'm going to do 6, really quickly. 1, I absolutely agree. Monitoring of the CEDAW treaty and women's affairs has to get out of social welfare. And that was a mistake from the beginning. It has to be fixed. 2, we do need to expand the scope of our equal opportunities legislation. My suggestion for sexual orientation and gender identity is that we not do a new bill. I think we should do an amendment to the SDO. It would be simpler, and let's face it, these are all gender-related areas of discrimination. It should have been in one bill to begin with, in my opinion. And we would also avoid some of the horrible inconsistencies that we see between the SDO and the RDO. 3, we need to review the enforcement model. Too much is on the EOC right now. I still think that we need an informal equal opportunities tribunal. And I also think that we need to push the government to comply with the Paris principles in appointments to the EOC. 4, employment discrimination and equal pay for work, equal work, and equal pay for work of equal value is an unfinished task. It's a really difficult problem that Anna tried to tackle. There was a task force. I sat on it at the EOC. But one of the problems is that job evaluation is very difficult to do, and so perhaps a better way of attacking unequal pay is to attack job segregation. And I was shocked at how many jobs in the government were still 100% male or 100% female when I was in the task force. I don't know if it's improved now, but I would like to find out. 5, democratic development, of course, is extremely important. In addition to being undemocratic, the current system of selecting the chief executive and the functional constituency seats all systematically discriminate against women because they are underrepresented. And moreover, the delay in meaningful democratic reforms has created a governance crisis in Hong Kong. And I think that is what is one of the barriers to things like gender mainstreaming, because until Hong Kong gets meaningful democratic progress, everyone's going to be obsessed with that, and it's hard to focus on equality issues. 6, we do need to protect the rule of law and genuine autonomy in Hong Kong. I have to say the events of 2015, especially the disappearance of the booksellers, are such a serious threat to the rule of law and Hong Kong's autonomy. I find them terrifying, frankly, and the most egregious violations of the basic law to date. So I think that we really need to focus on that. Women need to focus on that as an issue, because it's important to protecting the legal system here, which has been a very important advocate for women's equality. All right, alternatively or in addition, what strategies for engagement do you think might prove effective as we move forward?
Sorry, I'm going to come back to this. Yeah, I'm going to come back to this after we do the moderated discussion, so we can close on the strategies.
Okay, that would be good. Can I say one last thing then? Women are great leaders, and women, I think, are great collaborative leaders. And I do think that that is one thing that we need to think more about in Hong Kong. I agree that we have to sometimes fight like a dog, but sometimes we also have to show that we are prepared to negotiate and compromise, which you did mention, Emily, and I hope that we can do that. Thank you.
Thank you, Carol. So last but not least, Linda? Yes, so the rest of the speakers, we should just move over so you can see what picture they're saying. Yeah, but I think the PowerPoint is there, gets in there nice. I'll sit with you.
Actually, I'm the only one to get the PowerPoint because I got some photos, so I have to get back your memories about the old days. And old days. Actually, 20 years ago, I'm a very young social worker, just fresh graduate for 1 or 2 years, and then I worked in the Women's Center at that time. And actually, at that time, the center is the Hong Kong Council of Women's Center, and the present called Hong Kong Federation of Women's Centers because it's got independence after 1992, I think. And so at that time, I'm a young social worker. I work with the housewives and to advocate for their alternative roles, and also trying to making them more recognized by the society, because at that time these are the is there area? Oh, yes. These are me, very young, and these are the homemakers group, and they like to do a lot of community service, and also they will visit the Vietnam refugees camp. It's an open camp, okay, at the time, and we do a lot of support for the housewife, because we think that homemakers have a lot of contribution in society, but it's underestimated. And also, after because after they take care of the child, they want to go out to work, but there is no retraining for them at that time. And also the child care service, there is a lack of child care service. So at that time, 20 years ago, we do a lot to urge the government to set up child care service, and also to do more training for the women, for the housewives. And at that time, I think the most important thing is we always feel that women are not recognized, especially their unpaid work are not recognized. Only at the March International Women's Day, they will say that, oh, they're so great, they're sacrificed, but no service for them. And so at that time, we just think that it's unfair. Why unpaid work are not recognized? And even now, after they retire, they get no retirement protection as well. And so this is what I do at that time. And another thing is we also set up a New Tertiary Women's Group in 1993. And I wonder whether you remember this. I think at that time, the New Tertiary law that because at that time we got some from women from the new territories. Their daughters, they are not permitted to inherit their family land after the death of their parents in new territories. And I think 5 and 6 women, they come to the women's center and they want they're homeless because after their parents died and then they will be kicked out. And so that's why they want us to help them to form a committee. And so these are the ceremony held by the women's center at that time, and they do the opening ceremony and then they do some demonstration in the new territories and to speak up to their unfairness. And also this turned out to be a quite big movement, and because it earned a lot of public outcry and concern, and even the other committee groups like the anti-discrimination, at that time this is a group set up by them and they also support the issues. And this movement at the end it became the large social movement, and then in June 22nd, 1994, we successfully endorsed the amendment bill of the New Territories Land Exemption Ordinance to grant the equal inheritance rights to indigenous women in the New Territories. And at that time, I actually, from this issue, I have a very great reflection on it, because at that time there is a very heavy pressure from the great disease of the Hung Cook, that one is from the men, and they gather thousands of the villagers at the entrance of the electoral building. I wonder whether you were here at the time. I think most of the people are there at that time, and also they threatened to do some violence to the women who speak up their grievances. And all those 5 women, the 5 new territories women, they come out and speak up, and then they got the threatened calls on them from the men. And so, but what changed me is I learned a lot from the indigenous women actually, because I always think why they have the courage to speak up in this situation, and because it's their home, and then when they go back, their relatives will be very bad to them and have the bad treatment. And so this experience in participating in the inheritance rights movement, it also changed me as well. And I always think that they treasure their freedom, and also they treasure their rights to have their property from their parents. But if one day, if I'm in the dark era, will I have the courage to speak out, to protect my rights of freedom and expression. And so this movement really reflect and changed me. And in the past, I just think that our women need to get more support service. But afterwards, I always think that the first is they are vulnerable. They need the protection from the law. And so if we don't have the anti-discrimination law to protect these women and these vulnerable women, how can they have the equal rights in the society? So afterwards, and it also makes me feel that I need to commit more in the women movement. And also from this issue, I also see the unity among all the women's groups, and I find the force and the power from the collective action, although it's really very afraid during the period. But I find the support from the women's group, and so I also treasure the collective action and also the movement from the people. And this is the Beijing '95, and actually I went, and also we have, as Carol said, I think it served a platform for collective effort, and I look for our local women's groups to advocate for women's rights. And we have, at that time, we formed a 13 local women's organization. They are all serving the marginalized group and women. And we formed a Hong Kong Women's Coalition for Beijing, and then we prepare a alternative report to state our wills. And also, we also have the 10 delegates, including the housewife. And you can see from the Women's Center, they go with us. And although it's quite isolated, they are isolated from the other citizens or other residents in the Beijing area. But actually, it's a very great exposure to both the women and myself. And I think, to me, I got the chance to exchange with other women's groups in other countries, and also the Chinese women's group as well, and it inspired me a lot. And Also, I find that it is really important to have this kind of international conference for us and also for the grassroots women to voice out their needs and also to have more exchange and to widen their horizon. And instead of only concentrate on our local needs of women, we need to have more collective effort internationally. And so, I think the significance of the Beijing platform, to me, it also enhanced the local discussion about women's rights and gender equality. And after we come back, we are very excited, and we think that CEDAW is very important. We need to tell the local women, actually it's not only me, but our grassroots women from the center. We also think that we need to do more education to let people know about the discrimination and also the importance of the protection of the women's rights. And so after we come back, we do a lot of forums and do a lot of campaigns and advocacy. And this one is the English class by one of our English teachers. She is Susanna Ho. And so I remember this photo because she teaches what is CEDAW to the housewife women. And they are they feel very excited because they never know this. But because of the English class, they want to learn English. And so she used this chance to teach her women. And at the time, I remember there is a very positive response. And so this is a way, I think the Beijing panel is a way for us to try to use it as a tool to educate the women in grassroots as well, but in a very layman way. So, and also we also have a lot of forum and conference discussion as well. And then another importance to me of the Beijing platform is it inspired me to set up this association concerning sexual violence against women, as because during the platform, the Beijing platform, we share with some groups about the sexual abuse experience. We also think that in Hong Kong at the time, there is lack of visibility for women suffering from domestic violence and sexual violence. So I feel the urge to set up this, and in the past, people always think that violence against women is an unfortunate incident for women, but actually, we think it's the structural problem deeply rooted in inequality between men and women. And so that's why in 1997 we set up this association with 4 women activists, and then we want to have a zero tolerance to sexual violence. And in doing so, we do a lot. We set up a anti-sexual violence resource center. And for these photos in the middle this is the artist who helped to draw these 2 little Red Riding Hood, and it's a signature for the anti-sexual violence campaign, meaning that if a woman, she can enjoy freedom at night or even on the street, that would be great. And this is some kind of our future vision. And so we set up the anti-sexual violence resource center, and with the aim is to urge the government to do some policy to protect or even to do some prevent to combat sexual violence, to protect women and to combat sexual violence. And also we want to arouse the concern of the public about sexual violence. And then subsequently we also set up a special rape crisis center to address the special needs of women. And the name of this rain crisis center is Rain Lily. Rain Lily means that because rain lily is a kind of virus. It was slender little virus that grew a few days after rainstorm. So it represents the resilience of women. And also, we also have the one-stop rape crisis center to cater for women's needs because as you know, that women, if they are sexually assaulted or raped, they have to repeat their traumatic experience again and again, and when she reports to police, and the environment of the police is not so well, and so we want to set up a secure environment for women in a hospital, so women can do all the procedure when they report to police, including the forensic procedures and also all the statement taking. And also this one is the latest development, is a third rape crisis center set up in the Prince of Wales Hospital. So how far do you think that we have come? After 20 years, I think that some progress have been made. As you can see, the legal grounds to address sex discrimination, sexual harassment, and marital rape have some progress. But you can see as 1996, the EOC set out, and also the marital rape law have been amended in 2002, and also there is the law on domestic and cohabitation relationship violence ordinance as well. And secondly, I think the Women Commission also set out to devise the long-term strategies and comprehensive policy for women. But I think we still have some more to go in future, and some rooms of improvement. Like first one is about the gender mainstreaming and gender neutralizing. We still think that the Women's Commission, when they do the gender mainstreaming, they are not fully implemented in the government department. And as I just got one example, can you see the difference of these photos? Can you see the difference? The right-hand side actually is a photos that it's not a photo, it's a poster designed by the police, and they would like us to distribute it to Lang Kwei Fong in the eve of Christmas. And the left one actually is done by the postal and by the police, and you can see that it's asking people to prevent sexual violence. And in this logo, it says that don't be the next victim. And do you feel there is any difference between these photos? For these photos, we think that the police, because the reporting rate is recently is high, and then the police want to warn the women that don't be the next victim. In other words, they tend to put the responsibility of preventing the sexual violence on the victim. And the second photo is rewritten by us. We should say that instead of saying that don't be the next victim, we should say don't be the next abuser. Because from the police point of view, actually we are doing the opposite work. Really, and are doing the work that we should we should help the victim, but the police should be asking the perpetrator to warn the perpetrator, don't do something bad to the victims during Christmas Eve, but it's always the opposite. And so I just quoted as an example that these are not gender mainstreaming. Actually, is trying to put the blame and the responsibility on women. And so this is what I want to emphasize. And so another thing is, because I'm a social worker, for many years, we want to set up a support service for women, including we do a lot of supporting work for housewives, and also later we set up the Rape Crisis Center, hoping to provide support service to victims of sexual violence. But until now, women was not recognized as a separate category in their policy making, and from the view of the social welfare department, they only focus on service provision, and also you can see both Women's Center and also the Rape Crisis Center, the rape unit that I work have alongside, and we need to raise money by ourselves because the government think that it had been included in their family service. And so women are still under the umbrella of the family service. And because of the time, I'd like to mention the last one is the lack of the legal reform. This is also what we feel is the most urgent, because I wonder whether you know or not, the rape law had been set up 15 years ago, and it's really outdated, and we should modernize the law. But in fact, until now, the Law Reform Commission had published a consultation paper, I think 2 years ago, they would like to modernize the rape law, but until now it seems disappear. And we have given all the public views, and we have the NGOs have already given a lot of views, but no response from the government, and nothing has been progress. And so this is what we think important. And lastly, yes. And lastly, I think maybe in this discussion we can raise more on the future strategies, that what we can achieve in future. And in the past, we used as an NGO, we used several strategies to achieve a goal. The first is we would lobby the electoral council and government or the policy change through the press conference or through meeting with the electoral councillor to do some law amendment. But as shared by Emily, she said that it's quite difficult now to get a consensus from the different electoral councillors. It is also the difficulties that we encounter as well when we try to set up a law on the protection of women in court trial. And we find that it's difficult to link up all the electoral members together. Although sexual violence issue is already a very less sensitive issue, but this is the things that I want to have more discussion, and you can give us more views on how to do it. And secondly, our second strategy is we still believe that the needs of the women need to be identified themselves. They need to think about their needs and then have it reflect to the government instead of the top down, that the government telling that the women need something and then they do the policy. But so that's why for many years we will do a lot of campaign to encourage women to voice up, to speak up their needs and also to have their own voices. And this is another strategies. And the third strategy is I still believe in solidarity, and we hope we have organized local women's group. I think not only the women, but also women of ethnic minorities and also sexual minorities, we should link up together to have joint effort to combat discrimination in society and through them to set up some laws and measures. And these are the third measure. And the last one is to bring the issues of concern to the public and international community through platform of Beijing +20. And these are the four strategies now we are doing. But in this situation of Hong Kong, maybe we can have more discussion on, is this strategy still effective, or what do you think? Maybe we can have some other new strategies. Thank you.
I'd like to invite our panelists back up to the front table, please, and Man, thank you so much for switching off the projector. So as everyone's filing back around the table, I just want to say thank you all. You've been wonderful students because you kept to the brief that I gave you. You were timely and very strategic in answering questions. If you thought it didn't apply to you, you just moved on, which is fabulous. And I think you've all provided a very nice picture of how sort of things sort of fall together in terms of where we began 20 years ago and where we're at. And I think the case study, in a way you could say, that Linda sort of spoke to, gives us insights into where we are in terms of strategizing and working together. So we have the finer detail as well as the broader picture. We now, because everyone has been so timely and good in keeping their time, we have about half an hour for questions and further discussion. So I've opened up the floor. If you'd like to ask a question, it might help just to identify yourself briefly and put your question to any particular speaker. Yes, Sue.
Thank you very much. First of all, I'd like to congratulate all the speakers. It's wonderful to come for this journey. I think all of you are so courageous. It's quite an amazing journey that you all have walked, so I'm very grateful for all of you sharing the whole thing. I've had some involvement, in and out too, because my roots come from Malaysia. I started the women's refuge movement in Malaysia. So when I came to Hong Kong, it was working with people like Linda at that time in Harmony House. So it was through the NGO, but I was a prosecutor in the Hong Kong government at that time. But obviously for Beijing, that meeting, I was heavily pregnant. So even though I could go to Beijing, I couldn't actually get on the plane. They wouldn't allow me. But the point was, Anna and myself were in Beijing +5 in New York. Remember that, Anna? And with Priscilla. And I think the journey has been very long. I was also asked, because I was with Human Rights Commission in New Zealand, asked by the Welfare Bureau, Social Welfare Bureau, about when we wanted to start Women's Commission. Just to share with you, when the proposal came to me, I said, that's a toothless tiger. Big in name, but really not really doing very much. But they wanted to go ahead with it. So in all these years, I have made presentations to the Women's Commission and urged them to be much more proactive But they keep telling me that they really have no, no power, they were just advisory. And then I talked about that gender mainstreaming tool that they have. And asked for a copy of it. It's just a sheet of a few papers, it's a questionnaire, not going anywhere. It's a paper exercise. I told them this is just rubbish. I was very frank with them. In New Zealand, what happens is that for any laws that go through Parliament, there's a financial implication thing for every law going through or any amendment going through. But there's also one that has to emphasize on the human rights tick box, which is you have to consider vulnerable groups, and sex is definitely one of it. And so every minister knows that it's important to bring in sex into, you have to consider women's participation, youth participation, disability, also participation in it. So for any law going through Parliament, one has to seriously consider. And I, in the Human Rights Commission, I get to see that. And I challenge the ministers that you haven't really considered this. Why do you have in this section saying this? And that would, be against, I don't know, this, groups with disability. Then they have to start thinking, because their law is not going to get through if, they haven't considered seriously the rights of different groups, the diversity of people, the kinds of people living in a community. So I was heavily critical of the way that Hong Kong decided to pay lip service and to set up a women's commission. But I've also tried all these years to engage with them and made a lot of presentations to them and urged the Women's Commission and Stella to, and even before Stella, whatever the chairperson is, that it shouldn't be just, a look pretty thing. There are a lot of issues in Hong Kong that needs concrete and practical steps forward. Women are getting increasingly marginalized, and the feminization of poverty in Hong Kong is tremendous. You walk on the streets of Hong Kong, and who are the people getting cardboard in Hong Kong? It's all women. It breaks my heart that in a very rich society like Hong Kong, you have mainly women, old women, putting around cardboard to sell for a few dollars. It's not good enough. So I've come today to hopefully see that we have some strategies moving forward, some practical things that people in Hong Kong can do, that sex is something that's brought back in. The laws, as Carol said, it should be a one-stop shop. It should be one law, everything in it, rather than bits and bobs all over the place, and it gets watered down. Also, in the way we appoint people to important institutions like EOC. The Paris Principles are really important. I lobbied for that. In New Zealand, when we negotiated the Paris Principles, it was really important in a very transparent way that we want to put champions into essential positions, like the Chief Commissioner of the Human Rights Commission. That's another thing. Much more based on sort of input from NGOs, from civil society, from all walks of life. And it's crucial, because in the end, that mouthpiece have to be, standing for what's important in the multitude, in society with different needs and the diversity of requirements. It's really crucial. So thank you very much.
Thank you, Sue. We're just going to see what the question is, and then I'll invite the panelists to reflect either on what Sue has said or answer the question. Yes.
Maybe this is a bit of a follow-up question. Alexander Cook from the Philosophy Department. And my question is about the actual legal conditions on the ground for people.
Could you say who it's addressed to, perhaps, or?
Well, maybe more Carol. Maybe yourself, you're also a qualified barrister. If you feel you've been discriminated against in Hong Kong, what you actually do, can you afford to bring a case? My understanding is there is no option for class action suits, say for women who feel they have a common plight in employment. They are not able to join together to bring a suit. This has been a huge motivational factor in the United States. Something for the people who are making employment decisions to think about. And the other thing that seems to be, in fact, illegal is for a solicitor to accept a contingency fee. So basically, we're looking at the complainant having to just pay, sometimes upfront. I understand there are cases like this, or putting a deposit. I mean, there are huge financial barriers to individuals actually realizing their rights. So it's lovely to have all this wonderful verbiage on paper in the form of the SDO. I hope I don't sound too off the wall saying this, but I mean, the actual on-the-ground situation is that it may not be practicable for a person who feels they've been treated improperly or unjustly to actually go through the courts. And I think this means that the people who would ask, are you using birth control in the job interview, will feel free to continue, if not in that open a way, in a maybe somewhat more veiled way. What is there to stop them?
Thank you.
Thank you, Alexander. This is a distinction between, not just between Hong Kong and the US, but between most countries and the US. So yes, in the United States, we try to give employers and other institutions an incentive not to violate the law by allowing lawyers to take cases on a contingency basis. That's not just discrimination cases, that's also basic torts. And what it means, for those of you who don't know, is that it's ethical in the United States for a lawyer to agree to take a case for a plaintiff and receive no fee, but to agree to get a percentage of the damages. And it can be typically up to 1/3, and lawyers can get actually quite rich doing this, and so they're willing to take cases if they're good cases. We also do have an Equal Employment Opportunities Commission in the United States, which will give free assistance, but they litigate very few cases. And the rule is under Title IX is that Title VII, rather, the employment discrimination provisions in the United States, you have to go first to the Equal Employment Opportunities Commission, and then they give you a right to sue letter if they decide not to investigate your case or to sue for you. And the other reason, though, that, I mean, it wouldn't work in Hong Kong or most countries, because in most countries it is considered unethical for a lawyer to work on a contingency fee basis. And I have to say, there are good and bad things to the system. I mean, we do have what they call ambulance chasers in the United States because of that system. So there are some problems with it. The other reason, though, that I don't think it would work here, frankly, is that one of the reasons lawyers are willing to take those cases in the US is not just that they get 1/3, but the damage awards are big. And they're big because we have jury trials in the US for civil cases, which you don't have here. So the model in Hong Kong is based more on the Australian, New Zealand model, where you are less likely to get a big judgment in court, but you are provided, one hopes, with free services by the Equal Opportunities Commission. And that's one of the purposes of the Equal Opportunities Commission. So if you have a complaint, you bring it to the EOC. The EOC will provide free investigation and free conciliation. And if conciliation fails, then the EOC can consider whether it wishes to litigate on your behalf. And some of the very important cases that have been litigated in Hong Kong have been litigated by the EOC, right, for plaintiffs. Now, back in the day, I and a group here at Hong Kong U, we did a study of investigation and conciliation and the enforcement model at the EOC, and I just gave Amy a copy of the book, which I can share with you at the tea break if you want, that we produced. And we, fortunately, Anna was then chair of the EOC, and the EOC did give us access to data. And I would hope the current chair will be equally open if someone would like to do a study now, because it's very, very important. The names were scrubbed, so we didn't have access to anyone's names, but we were able to analyze over 400 case files. And what we were looking for is what complaints were being made, what were the remedies, how successful was conciliation, how many cases got legal assistance, etc. What we concluded is that the current model is too weak in a few important ways. One of the reasons it's weak is that a complainant does not have the right to ask the EOC for legal assistance until conciliation fails, which means that when she's mediating, right, she has no idea if she's going to get legal assistance. And so it's in the interest of the respondent to offer something very low. And we saw cases where they offered something very low, and then the complainant has to decide, do I take it or do I risk getting nothing because I don't know if the EOC will support me, because the EOC has a very limited budget. I think it would be much better if she had the right to ask for legal assistance in the beginning, so that she could say, if you don't give me a decent settlement, I know already that the EOC will support my case. And I can tell you just anecdotally, once I was informally assisting someone with a case down there, not as a lawyer, because I wasn't licensed to practice law in Hong Kong, but you can go in just as a friend. And it was a person who had a sexual harassment complaint. It was a really good case. I mean, it was a strong case. And the respondent was represented by a lawyer, and he just kept saying, no, we're not offering anything. So I called up a friend who was a solicitor in Hong Kong on one of the breaks, and I said, I need you to represent this woman pro bono because I can't, I'm not licensed here. And she said, ooh, I don't know if my firm would like that. Because politically it was considered a little, dicey to be saying you were going to be representing someone pro bono sexual harassment case. And I said to the solicitor, I guarantee you won't have to do a thing. All I have to do is go back into that conciliation meeting and say that my person here has an appointment to see you at 10 a.m. tomorrow morning, and this case will settle today. She said, okay, she believed me. I walked in, I said, here's the name of the solicitor that's going to pro bono assist this case. We had a settlement that afternoon, and it was a pretty hefty one too, because that lawyer knew that if that case went to court, they were going to be on the hook for some serious damages. So this is the problem with the current system. Unless somebody knows that they can go to court, the respondent has too much bargaining power. So in the study that we did of investigation and conciliation, our recommendation was first that the Equal Opportunities Commission should not be the only avenue. There should be an informal Equal Opportunities Tribunal, which is present in many countries, where a person can know that they can go even if they don't have an expensive lawyer to represent them. And secondly, I do think someone should be able to get some advice from the EOC in advance from the legal services side, whether or not they would get legal assistance. And thirdly, I hope there can be more pro bono legal assistance. In the United States, one of the things that helps people who have human rights complaints is that there are a lot of pro bono services available, a lot of legal clinics at law schools. I know there have been difficulties with setting that sort of thing up in Hong Kong, but I do think it would help to make the model more enforceable. But in answer to your original question, class actions and contingency fees, I doubt are going to come to Hong Kong. So my suggestion is that we work with strengthening the model that we have here.
I just want to follow up on that issue and give you some perspectives that I have, I was privy to. One is, one of the recent, I shouldn't say recent, one of the Law Reform Commission reports is actually on this topic. And that was done some years back, but it's still one of the more recent ones. And the approach taken in that report is to home in on class actions vis-a-vis specific areas like consumer. There are a lot of difficulties involved, but if we want to get started on something like that, find a workable strategy that can take it forward. And usually law reform reports of that sort, it would take you at least 10 years before you get anywhere after publication. That's in addition to 10 years of study before. So it'll be a lifetime. But I think the report is worth looking at, and I really think that we should give it a better push, because it's not just the consumer actions. There are things like minority shareholders, there are things like competition issues today, and there are lots of discrimination issues. So that's one, there is a report on it, and it's not well publicized. Number two, Carol referred to the tribunal setup. It was one of the things that I actually wrote a paper on before I left office, hoping that the next one would take it on. But somehow it's died a death. And this is something worthwhile bringing back, because lots of people would like to be enabled to take that case by himself or herself. EOC, forgive me for saying this, my understanding is there are, at the time I left it, about 1/3 of the cases given legal assistance, because it selected on the basis of complexity of issues and number of people involved, and certainly harm involved. So there is a prioritization system. And I can't see that being changed unless you give a lot more resources to the EOC. The one thing that Carol and I did right was to build into the district court rules for all claimants under discrimination, not to be penalized by costs as a plaintiff if that person failed, unless the case was completely vexatious. It's a matter of discretion for the court. So that's there, but it's minor relief because the claimant would not have to pay the cost necessarily for losing. Now the other aspect that's worth looking at, which we tried at the time of legislation, was to build that into the legal aid parameters. Because the legal aid actually has a discretion to give legal aid on all Bill of Rights cases. It's not necessarily means tested. So if you could put specifically EOC discrimination cases under that bracket, then certainly the resources would be better. I mean, those are the things that we've tried before, and it's worth going back to it. I do have a number of strategy issues that we can come back to, but just on this point alone, and on a couple of very practical points, for instance, that Linda mentioned, one of the things that we should be doing as a group, even if you cannot put it to the legislators for a full meeting, a debate, or a special dedicated committee, you can actually ask for a meeting with the panel on constitutional affairs and ask for it yearly and say, I've got a report for you on the performance of all these issues. Come up with a report. Now, whether it be in LegCo or anywhere else, we can do this because it can be an open forum outside LegCo as well. And I would welcome that because some of the issues that Linda has in mind could actually be factored in. Now, there are a whole lot of other things that I can mention, but one more thing, if I may, Pooja. I want to explain why I said you've got to add the title of Human Rights or Equality Minister to the Constitutional Affairs Minister. Equal opportunity started with Home Affairs from memory, moved on to health and welfare as a welfare issue, and then later on moved into constitutional.
But only partly, because the women's stuff is still with
Right, right, but this is typical Hong Kong.
Yeah, right.
Typical Hong Kong government, I shouldn't say typical Hong Kong. Because notionally they say this belongs to this, and if you look at the website of Constitutional Affairs, you will see EOC and human rights under his portfolio. But he does not take responsibility for these issues. When you ask him, he would say, well, it belongs to welfare, Matthew Zhou. Labor, Matthew Zhou. Health, breast cancer screening, is there enough of it? Ah, that's health. So don't let people get away with that. And that's why I say you've got to identify someone and call him by another title and say, I don't care what else you do, but you're responsible. I'd like to be able to talk to you. If you sub-delegate, that's your business, not mine. So that's the reason why I said we need to create these titles and put it to one minister. And at the time when I suggested to the Health and Welfare Minister, I said I objected to this being under welfare, but if you assume the title of Minister for Women or Women Affairs specifically, then it would be a different level. And the person I proposed it to was E.K. Yo, and he happened to be a single, unmarried bachelor. And I was sure that he didn't like the word women affairs. So we deal with the rest of it all.
Thank you very much. And I'll just add, Alexandra, I'll be happy to send you the report that Anna mentioned. And I remember this clearly because when I entered law school in 1997, that was one of the prescribed readings for us. Sort of why do we not sort of have contingency and conditional fees in Hong Kong? And I'll only say that at that time as well, and more recently when we've looked at this issue, it's been 20 years, and the professions, so the bar and the Law Society cannot make up their mind on whether this is a good move for Hong Kong. But now they're studying what's happening in the UK because they have introduced a limited model. So we're trying to, of conditional fees, not contingency fees. So we're trying to see if they manage fine without some of the problems. And so maybe we might be able to model that. The only other thing I'd add also to what Carol said is when I've worked with different groups, whether it's women or racial minorities in Hong Kong, and we've tried to approach the EOC for assistance, in addition to some of the issues that Carol mentioned, we also have found that the threshold to qualify or satisfy the EOC that we have a strong case is incredibly high. And if you think of how people litigate in general, they don't look for 100% or 90% chance of success. So to put victims of discrimination to that standard, I think is a disservice to them, and that's something that needs to be rethought. But perhaps we can revisit that later when we discuss EOC more comprehensively in future exercises. Petula.
Hi, I'm so glad to see Professor Chen, the new EOC chairperson here. So I would like to ask him, what do you think about Carol's suggestion regarding protection against discrimination on the ground of sexual orientation? And then following on Emily's earlier sharing, how would you deal with the scandal surrounding you and carry on with the work that you want to do when you first take on the chairmanship? And then, of course, I'm sure people in the audience would like to hear your response to all the suggestions made by the distinguished panelists. For example, this new Minister of
Human Rights and
Equality.
Thank you. Dr. Chen, do we trouble you?
Right. I think Carol's suggestion, I don't have any problem at all. I think that's very conversant with what I'm thinking. And obviously, I think in reality, whether it's easy to get government to do that, I think would be obviously another matter. Those issues clouding my taking up of this position, I think I need to respond to it, and I'm responding to all those issues, in particular for those non-reported engagement with outside practice. But that actually that's a bit complicated. I have already actually reported this to the press, so that was a gist of the matter. But I'm going to do it within the committee as well. So yeah, allow me the time to do that. As a general reaction to today's all the presenters, I think, have made really enlightening presentations, for which I think I definitely share almost, I think, each and every one of those points. Regarding the creation of human rights and equality minutes, I have the same feeling. In fact, I had a meeting with my staff yesterday. I was asking the same question. And regarding to earlier on the question on why couldn't we provide legal assistance right at the beginning rather than actually going through the processes that Carol just described. Now that has a lot to relate to resources. In a nutshell, we were only given less than $500,000 for litigations. So now that's the whole budget for thousands of inquiries. So that explains partly why I think EOC could only be, have our hands tied on giving legal assistance to applicants. But nonetheless, I think this will be, I think, a struggle, perhaps a right direction too for us to speak to CMAB about, if you give that sort of budget, obviously, I mean, if it's government intention, reflecting government intention that, they don't want litigations outright. So that might be, looking bad on the government too. So I'm going to take that issue with CMAB. Now, Anna's paper, I think I definitely would want to